Broadcasting from the business capital of the world, this is the Podcast Business News Network.
And welcome back, everyone. This is What's Law Got to Do With It? We use this podcast to take a look at our legal system and litigation and so much more. Today, we're going to look at the criminal justice system, our court system, but a little bit different this time. We're going to attempt to filter out the political side of it and just look at the fundamentals of our court system and how it's been changing and what's going on currently. She's somebody that always has her finger on the pulse of our criminal justice system. She specializes in construction litigation in that arena, but she looks at everything. She's based in New York City. Our professional of the year, Carol Sigmond, is back with us. How are you doing today?
I'm doing very well, Steve. How are you?
Very well as well, and intrigued to go here. And I always say, I don't do politics. I don't do religion. I don't get into it. I don't want to engage in it. It's just that's the way I am. So I'm intrigued to see how we can do this today with looking at some of the decisions in our courts, the direction that they're going in. But, you know, I used to remember my grandmother cooking with the big strainer, you know, filtering out everything and filter out the politics here. I'm thinking that we start with an email we got that's kind of in the wheelhouse of what we're going to be talking about. And by the way, you can reach us, comments, questions, anytime, instant feedback, steve@gmail.com. This is from Jess in Denver. And Jess says, I'm seeing the cost of groceries, coffee, and cars going up quite a bit recently. Do you believe that reflects the tariff situation?
Yes, it does.
To all of those?
Yeah.
Wow. Okay.
It's particularly true of coffee. It is very true of anything with metal in it. It is also true of anything that is coming across the border in the way of foodstuffs from Mexico. The tariffs are starting to filter in.
I just, funny you should say this. I don't mean to cut you off, but I got my coveted cup of coffee here. And I buy it at a convenience store. It's my little me present every morning. And it's not about caffeine. I don't even do caffeine. It went up. It went like at least a quarter a cup, maybe a little bit more depending on which convenience store you go to. I was wondering about it myself, and I got to think, it's imported, so probably is part of the tariffs. So
what happened with the tariffs from an economic point of view was that when businesses saw them coming, they stockpiled as many goods as they could. And they continued to stockpile during the periods of time that the tariffs were suspended. Now they're all hitting. The stockpiles have been eroded, and the businesses are now having to pass the cost through. They are not fully through. This is the most observers think that the inflation that we saw in August was due to the tariffs. It's hitting food. It's hitting women's clothes particularly hard. It's hitting shoes like Nike and athletic shoes. It's going to be hitting phones and electronics. It's all getting hit. It's going to hit. And some of the tariff increases are going to be one-time expenses. For example, if my iron broke down, okay, and I had to get a new iron. Pre-tariff, it was about $10. Post-tariff, it's about $40. That's a one-time hit. I won't buy another iron for a few years. Fine. But all I'm saying to you is some of these are one-time hits. Cars are going to get hit particularly hard because of all the metal in the cars. Construction materials and construction costs are definitely going to be moving up. The labor shortage associated with the approximately 1.2 million undocumented workers who have left the country in the last 9 months or so is going to contribute to that as well. But we are now starting to see the real cost impacts of the tariffs.
Interesting. I wasn't aware that there was a stockpile, depending on what the goods are, that we were, I guess, feeding off of for a while there, because we didn't see an instant increase when the tariffs were announced.
Well, some businesses chose to sit on them, to eat them for a short period of time, but they can no longer do that. And they are now passing the costs along. And they are going to hit, if you look at statistics, roughly 50% of the population in this country spends about 85% of the dollars. And the other 50% spends about 15%. That 15% has already been hit very hard because the essentials they need have been hit hard. The other 50%, the people with more discretionary income, are now going to really start to feel it. That's part of the reason the president has been desperate to try to get a rate decrease. It's the inflation being caused by these price increases are the reason that the Fed has been holding the line. I think we're expecting a quarter of a point today. It may have been announced already. I'm not really sure. But I think that these are many of the economic challenges that we're facing, and this is going to continue. So the questioner asked the right question. We're there.
Wow. So I don't want to be negative here. I'm just asking, can we expect the prices to continue to keep going up?
Yes, according to the economic data that I've been seeing, BAML, and some of the other investment houses, I think we're only about halfway through the price increases, so people can get a feel for what's coming. It's going to be even more. So if your coffee has gone up a quarter, it's probably going to go up another quarter, just as a sort of a way to handle it. Some of the shortages we're starting to see on the grocery shelves are going to continue as the wholesalers and retailers try to adjust to the prices. If you're in love with a brand, make sure you've got an alternate as a backup, because I think we're going to have some spot shortages as well. But I think the bigger thing we're going to be seeing is more price increases, and they're going to be hitting things, not only big at costs like cars and trucks. They're going to be hitting things like coffee. That's going to be hit very hard. Chocolate's going to be hit hard. I don't know that it's been hit as hard yet, but it's going to be hit. So this is the reality of the tariffs.
Wow. So we're talking about the justice system, how things are sitting in the courts right now. Let's look at that in regard to the tariffs.
Okay. So at the end of August, I think August 29 to be precise, the United States Federal Circuit of a Court of Appeals rendered its decision on the CIT on the IEEPA tariffs, which are basically the reciprocal tariffs and the fentanyl tariffs. Those two sets of tariffs are under the IEEPA, the International Emergency Economic Powers Act. Those tariffs were found to be unconstitutional by the CIT in May. The Court of Appeals found them to be unconstitutional by a vote of 7-4 in August, at the end of August. The Supreme Court granted cert a week later. The decision of the CIT has stayed, so the tariffs are continuing to be collected because they can be returned. So that's the current status. The Supreme Court has issued a briefing schedule. The government's brief is actually due day after tomorrow. They consolidated a case from the DC Circuit and a case from the CIT, and they've put those cases together. A third case from Montana involving some unique issues for Indian reservations, they have applied to join this group. The Supreme Court will be issuing a decision about that, I guess, in October. I'm not exactly sure what's going to happen. The dates for the amicus have already been set. And so we're underway at the Supreme Court. They have already announced that the oral argument on this matter will be held the first week in November. So the tariff case is moving and moving rapidly. But let's understand what the arguments are. The 3 justices of the CIT, the Court of International Trade, and 7 justices out of 11 on the Federal Circuit have said the president does not have the power to invoke these tariffs. The four justices in the minority didn't say he did, and they didn't say he didn't. What they wanted to do was have a better developed record on something called regulation and whether or not the reciprocal and fentanyl tariffs are in the nature of a tax or a regulation. It's an interesting argument. I think it's a difficult argument to make with real intellectual honesty, because you have to begin with the Constitution, and the Constitution clearly puts tariffs in the tax category. So they're not really a regulatory item. They are, by Constitution, they are a tax, in the hands of Congress. There is an enormously complicated argument about whether or not there is some kind of discretion granted to the president by Congress to invoke tariffs of any amount he wants. But the better argument probably is that he cannot. And the argument of the majority in the Court of Appeals was, look, where they gave the president express tariff authority under the 1962 and 1974 acts, they are limited in amount, they are limited in duration, they require congressional extensions, and they can be challenged based on the record. The IEEPA tariffs, there is no such provision, but tariffs aren't included. The president has different kinds of powers under the IEEPA, according to the majority, that do not involve this tax authority, and it has to do with other types of regulation. Now, the most recent use of the IEEPA before President Trump was by President Biden when Russia invaded Ukraine. Everyone knows that the Russians were cut off from the so-called SWIFT banking system. That was an exercise of presidential power under the IEEPA, which was authorized. There was no judicial challenge that was something that's more or less spelled out in the statute. The president has the right to embargo a bad actor, and cutting them off from the SWIFT system is an embargo. So that's how the majority sees the IEEPA. We don't know about the Supreme Court, obviously. And this brings us to a very important sort of thing to think about. So you have people who say, well, the Supreme Court is doing this in a big hurry. That's because they're going to support Trump. They're going to do this. They're going to do that. That's not the way to analyze this. The way to think about this is, will the Supreme Court essentially say that the president can regulate the entire economy with no check from Congress? If the minority in the federal circuit, if their position were to be adopted, any president, not just the current president, any president could just use the IEEPA unchecked by Congress, unchecked by the courts, make any kind of economic rule they want. That's the logical extension of the arguments put forward by the administration and the minority.
Well, Carol, back, I want to say in the spring, didn't Trump declare a national emergency talking about the trade deficit, other countries, the drug situation? So that was his... We're not doing politics
separate
here again. We're just...
No, those are two separate... There are a number of national emergencies that were declared. There was a set declared on fentanyl and a set declared on the reciprocal tariffs. That's correct. And if you were to... The IEEPA doesn't really have a mechanism to test those. You could test them in a very narrow way, but not in the way that you can test the tariffs under the 62 and 74 acts. So it could be considered an unchecked power. Generally speaking, in our system, unchecked powers have not been favored, unless, of course, you're pushing the unitary executive theory, which is, of course, Project 2025, and is a philosophical approach by some people who think that the president is the only ultimate power, and Congress and the courts are secondary powers, and the so-called unitary executive has more power. So the question of the unitary executive is now going to be foursquare before the Supreme Court. The institutional authority of the courts is now for full square before the court. And the question of whether or not the president's power can be checked by the APA or other mechanisms is now full square before them. Because if you were to say that the president can say whatever he wants as a national emergency and you can't second guess it, you can't test it, you can't check it, we have a problem.
This is where I was going with that, and thank you for bringing that up. What's a national emergency? The price of coffee has gone up. Some would say that's chocolate.
National emergencies, in my mind, sound a lot more like War and Peace.
But you know where I'm going with that.
I know where you're going. Yes.
How do you determine what is a national emergency? And if in the IEEPA, it could be it's a free for all. Doesn't matter what party you're with. I just wonder about that. What are your thoughts?
Well, that's why I don't think that they're going to find that much power under the IEEPA. They're going to find it's more restrictive.
Okay.
That's why that should be the interpretation, because the other two statutes where there are greater powers expressly granted, there are checks. There are limitations, there are checks, there are time limitations, and the national emergency itself can be tested. For example, if you want to invoke the 1962 Act, you have to find a national defense emergency. You have to find an actual defense, an actual emergency in trying to provide for the national defense. If you want to invoke the 74 Act, you have to find some kind of unfair trade. Now, let's be clear, administrations of both parties for a number of years have issued various, if you will, tariffs and other regulatory schemes against mainland China, because there have been real issues about currency manipulation and also access to markets. And those have been challenged in court. They have been upheld. They have been modified. But those have had judicial challenges, and everyone abides by the decision. Now that's the Chinese tariff piece. And while the Chinese tariffs might go down, they are not going to disappear, even if the Supreme Court sustains the Federal Circuit's decision. Some of the tariffs on China will not disappear. The fentanyl tariffs have to get tested. They haven't really been fully tested. The market hasn't been completely tested under the 74 Act. Some of that could come back under the 74 Act. The president could find he might be able to use the 74 Act for some limited issues on fentanyl. It won't work against Canada because Canada's not involved in the fentanyl trade. It might work against Mexico. I don't know. The Mexicans are working very hard to control the fentanyl trade, so it might not work there. But 100% don't disappear. The president does have the 62 and 74 acts to look at, but they are much more limited in terms of amount, duration, and purpose and basis. They are not like whatever number the president decides he wants for whatever reason, because he's decided it's a national emergency. And one of the things that you'll notice is there hasn't really been a testing of whether or not there was a national emergency. The president declared the trade deficit a national emergency. Most trading authorities, most economic experts say that's not a national emergency. It's longstanding and not particularly harmful to the economy. So it's a difficult issue, but the Supreme Court, I think, has to decide some very hard issues on the role of the courts, the role of the executive. And it's not just, do we like Trump or not like Trump? Do we approve of his policy or not approve of his policy? There are some big institutional issues at stake here.
Now, Carol, we're talking about November, this being revisited. If the Supreme Court strikes down many of these tariffs that Trump issued. It's a possibility, is it not? Okay.
Yes, it is.
As consumers, what can we expect? What do you think?
Well, that's very interesting too. The initial decision of the of the CIT was to just abolish them. And they were going to do a national injunction and just do away with them. The Federal Circuit said to the CIT, we don't like your order. We agree with your decision. We don't like your order. We want you to go back and make the order more enforceable, more narrow, and more tailored. So I'm not sure how that will play out once the Supreme Court decides the case, but I think the case will ultimately go back to the CIT, possibly for some hearings on how to affect it. You'll see that the tariffs will not be collected anymore because it has to be the same all over the country. There's a lot of talk about the Supreme Court's decision in the birthright citizenship, where they said these nationwide injunctions don't work. We want more tailored injunctions or class actions. The CIT doesn't fit under that particular decision because by statute, they have to have the same rules in every part of the country. The CIT's jurisdiction is not geographical, it's topical. So when the CIT decides a case, it's for the whole country. They're not like the Southern District of New York or the District of Montana. They are a national trial level court with a limited scope, namely trade. So that particular part of what the Supreme Court has been talking about in things like birthright citizenship and immigration will not apply here. I think we will have to have a national solution, but I think it may have to be more tailored, and it may be that they are going to have to hold some hearings on some of these issues. So you'll see prices start to come down. You'll see, but not a lot, because price increases tend to be sticky.
I've heard this word, refund. Now, would businesses potentially get refunds? Doesn't mean that it's going to be passed on to the consumer.
The businesses that paid the taxes would be the ones entitled to the refunds. And that's part of what the CIT has been ordered to think about. How are you going to do that? Who gets to get a refund? Who gets to apply? In other words, is the refund limited only to the people who sued, or is it all businesses? That's one of the questions that I think they have to answer. Is everyone going to have to file a suit? How are they going to do this? How are they going to handle this? This is a big problem.
It almost reminds me of the COVID relief paycheck protection program, whatever it was called, where you went online, you filled some stuff out, and you got a check. Wow, this is fantastic.
That was a little simpler. This refund program is going to be complicated.
Yeah.
And I think the CIT is going to have to think it through a little more. That's what the Federal Circuit wants. I'm sure that's what the Supreme Court is going to want. And frankly, we should all want the courts to think through their orders and make sure that they are enforceable and manageable and are practical. And so I suspect there's going to be some tinkering around the edges of what happens, but it can't be one set of rules in California and a different set of rules in New York. That's prohibited for the CIT and the Federal Circuit.
What I try to get my arms around is the actual percentage of tariffs. Now, I look at graphs, different countries, they all float around 10%, ish. But then you get to, like, say, Brazil, I recall 50%. And I'm trying to figure out why that would be 50%. I'm not getting that. Canada, I heard, was like 35%. Why 50% Brazil? What was going on there?
Well, nobody's quite sure because the administration didn't have a report or a study that explained how they did the calculation.
Aren't they supposed to, shouldn't there be some rhyme and reason?
If it was under the 62 or the 74 Act, the answer to your question is yes, that's required. You have to explain Or if you will, like a kid in school, you have to show your work. You have to show your homework.
Right.
The IEPA doesn't have all of those mechanisms built in because I don't think it's intended to deal with this type. It's not intended for tariffs.
In your professional opinion, do you think it's faltered?
Do I think it's what?
Faltered. There's an issue here where it's not clearly defined. Here we go. Look at these. India, I think it's like 50%. Okay, why?
Most experts who have looked at the tariffs believe that the tariff was based on what the
dartboard.
No, what the administration perceived was the trade deficit for that particular country.
Okay.
And that was only in goods, not services, so that it doesn't bear any real relationship to the trade. I mean, that's why the penguins in Antarctica have the biggest tariff of all. Reason? We ship equipment to the stations in the Antarctic, but they don't sell. So it's a big trade sort of deficit situation there, and so it looks much worse than it is. But there's actually there's no reason for it. Vietnam has been hit hard too, I think, and that's going to affect women's clothes. Indonesia, Vietnam, the Philippines, the Caribbean. These are all places that are going to be hit hard with women's clothes. To a lesser degree, men's, but women's flash fashion in particular getting hit hard.
Wow.
And those prices are already showing it. They're already showing.
So we can pivot to another part of the court system. Anything else you want to add on, while we're talking about tariffs?
It's going to be very interesting. And all I can say is anyone who's really interested in this issue, I understand that they are long. There's several hundred pages of material between the CIT and the Federal Circuit, but it's interesting to read the decisions and read them for yourselves. I would urge people, they're easy to find. There's something called Court Listener. If you plug in the name of the case, Court Listener will bring it up so you can read it. It's a good idea. I agree with Justices Barry and Sotomayor that Barrett and Sotomayor, people should read them for themselves.
It is interesting, I have to tell you. And in the beginning, I didn't have a great interest in it, but as time goes on, and spot on, you said at the beginning today, it's speeding up. What's going on here, how it's going to be handled. It seemed like it was just kind of sitting out there. You had April to May to June. Now, ruling in last week, less than 10 days away. And now November. So yeah. Interesting. What else should we look at within the court system?
Well, there are a number of things that are also going on. We have, for example, we have a series of decisions starting to come out directly on point and also sort of tangential on some of the deployments of National Guard. So you have District Court Judge Breyer, who decided that the Posse Comitatus Act prohibited certain of the activities of the administration in Los Angeles with, National Guard troops or federal National Guard troops trying to enforce local law. That decision, the logic of the decision has not been disturbed, but the question of the injunction has been an issue. How the court crafted its injunction. And so you have a number of these injunctions that have been put in place, not only on Posse Comitatus, but a number of others that I think the Supreme Court thinks are not really enforceable. They're not practical, they're not sufficiently tailored, and they're not carefully done. And there's a reason for that. They are seeking to do this preliminarily before the trial. And in many instances, these constitutional issues play out through a trial, and then there is a decree. It's not handled in a preliminary fashion. So you have an administration that is trying to take some novel steps. You have the courts trying to respond to the novel steps. And the usual customary way of proceeding, which would be to go to decree stage, is being short-circuited with injunctions. And this, I don't think the Supreme Court and the courts of appeals like them, not because they think the district court judges are doing a bad job, but because these injunctions are so broad and so hard to enforce. And if you don't have an enforceable decision and you don't have an enforceable injunction, the court loses credibility.
Mm.
So there's a complicated set of issues there going on. I do think that Judge Breyer is right. The Posse Comitatus Act was violated by the deployment of the federal troops in Los Angeles, and that's a problem. There was a very tough decision earlier this week by a magistrate judge in federal court in D.C., dismissing some of the charges that have been brought into federal court by the federal policing activity in D.C., and he's calling it violations of the Fourth and Fifth Amendments, and he's being very unhappy. They're going to have to, the courts are going to have to be more careful, because these kinds of decisions are going to get made on these local levels, and they can't all be reversed, and they're not all going to be taken up on appeal. But it's undermining the law enforcement activity. So you've got some issues. You have the gentleman who threw the sandwich that they tried to file the felony on, and then the grand jury refused to indict. So that's not a good look. You need to be more careful and more judicious in what kinds of charges you bring and how you police. You don't want to undermine the credibility of the police and law enforcement. At the same time, you do not want them heavy-handed and treating people in an inappropriate fashion. So it's very unclear to me where this is going to go and how effective it's going to be, but it has not. The argument is it's been effective in DC because allegedly crime has gone down. Maybe not. A few people may feel more safe because there are more people on the street. Okay, that could be a budget issue. It's not 100% clear to me how this plays out long term.
This act that prevents the president from using the military in a domestic situation, a domestic police force, doesn't that go back to the 1800s?
Yes.
You think it's outdated?
No.
Okay.
No, I think it's perfectly appropriate. But let's be very clear. Posse Comitatus does not apply in the District of Columbia.
Okay.
That is a matter of law, been decided. That's a settled issue.
Now, why is that? Just so we're all clear here.
So the District of Columbia is a federal territory.
I figured that.
It's not a state. It's not part of a state.
Okay.
It used to be the current District of Columbia used to be part of the state of Maryland. A little piece of it was probably part of the state of Virginia, but most of it was part of the state of Maryland, not part of the state anymore. Originally, Virginia and Maryland each ceded some territory to the federal government for the District of Columbia. There came a time when a portion of it was ceded back to Virginia, which became Arlington County, Virginia. That is the portion that was ceded back. But it is a federal territory, and Posse Comitatus does not apply.
Thank you for that. There's some clarity there. Many of us don't, I wasn't aware. Because this case, we're talking about Louisiana and California, aren't we? Was Louisiana, I recall the National Guard being deployed in Louisiana.
You're thinking about Katrina? Are you talking about Katrina? I
don't know. I think if I remember correctly, it was more recent.
No. They're in Memphis now. They're going into Memphis now. The National Guard, Posse Comitatus does not apply if the National Guard is being deployed in a weather emergency. That's a different type of order and a different type of role. And it's not a police or governing role. It's a rescue role. It's a distribution of resources role. It's life safety. It's a different set of standards. That's
national emergency. It could come under.
Yes, a type of national emergency.
Yeah.
But the most common, the biggest deployment civilian deployment that I can think of a National Guard in recent years was Katrina. General Honore was in there basically running the city of New Orleans for about a month or so. But he was doing so under a completely different grant of authority. He was doing so, first of all, on a grant of authority from the governor, not the president. So it was a state act, not a federal act.
Yep.
But it was also they were not in there for the purpose of law enforcement. They were there in the purpose of for life safety. It's a different kind of order and a different kind of activity. So not implicating posse comitatus. Unless the state governor is going to support the introduction of the troops, the president is going to have a posse comitatus problem. So we're in Tennessee, where they've invited the federal troops in, the governor will sign the order, and they won't have the posse comitatus problem. If they were to go into Chicago over the objection of Governor Pritzker, they would have a posse comitatus problem because they would not have the state's support.
How do you think this is all going to shake out? Your intuition on this, your read, your experience. What do you think?
I think it's a myth that the big cities are crime-ridden and have all these terrible problems. And
this is coming from somebody who's sitting in New York.
Yeah. Let's be clear. Yeah. One of my neighbors was killed by a hit-and-run driver. So yeah, we see crime. I'm not saying there isn't any crime. But what I am trying to say is it's not what we saw in the 80s with the crack epidemic. You want to talk about a time when there were real problems, when you had all the crack epidemic and you had all of that crime on the streets and a lot of violent crime, sometimes between the addicts themselves. That is a different time. Different type of policing. There have been improvements in policing. I don't think this is going to be effective, and I don't think it's a real problem. I think there is a perception by some that the cities are terrible and, it's got to be this, that, or the other thing. I don't think that's the case. I think the cities have some issues, but they've also had, massive financial issues. I mean, take New York City. We send $15 billion to the feds and $6 billion to the state. They don't give it back to us. I mean, we're a net outflow of money for everybody else. Why is that? Why are we sending so much money? Why isn't there more money available for our issues? So there are a lot of issues to consider here. But I think overall the cities are not the lawless places, out of control, that the president is arguing or some of his supporters are claiming. It's just not that. It's not that way.
Do you think the media feeds into that?
I think it depends on the media. Some yes, some no. I think it's all over the place. The tendency of the media to sensationalize whatever happens does not help. I think frankly, I think city mayors don't always help themselves. I don't think they've been as serious and careful and thoughtful as they could be. I think one of the things that's fed the problem, both in terms of perception and reality, has been the reluctance of some of the cities to allow the federal government under both administrations, both President Biden and President Trump, to deport some of the people that are in the cities that are having significant contact with the criminal justice system.
And I think you'll remember, came out, maybe it was June, where New York City announced record low shooting incidents for the first beginning of the year. So, I'm stating the facts. Then again, you could have the other people who would say
we had other categories of crime increase. So it was kind of a net up and down. As a person who's in the city, my perception is that the large number of undocumented people that were pouring into the city who were in a lot of distress was not helpful to the crime rate. I think as that crisis has eased, the crime rate has eased a bit. But I also think that the city is, we can talk for a moment about the cases about Sanctuary City. There are a number of those cases floating around. So far, the administration has been losing, but probably they're losing because they're bringing the wrong case. They're trying to challenge the authority of these cities to have sanctuary statutes. But the city's sanctuary statutes, most of them are very carefully crafted to essentially require not that you can't deport, not that ICE can't do its job, but that under certain circumstances, ICE has to work with judicial warrants. And there's a reason for that. We don't want hospitals, schools, and certain other locations where people go. We don't want a lot of law enforcement activity. It's not safe. It's not safe for the general public. What we need is if you need to do something, you need a targeted warrant, you need to go there and you need to do it. In the case of the court system, there are competing interests. The administration thinks that the priority is to remove people from the country. But in some instances, the prosecution's priority is to have them remain in the country to testify against domestic criminals. So we have all of these competing policies, which is why the warrant requirements came in, so that they could be dealt with in a more thoughtful way. So the sanctuary cities aren't saying you can't do this. They're saying you need judicial warrants. Well, in order to get judicial warrants, you need enough judges, and Congress hasn't funded enough people to issue enough warrants. And that slows the process down. So the administration's trying to work without warrants. They're trying to work with what they're calling administrative warrants, and that's yet a different problem. So the sanctuary cities didn't entirely help themselves, but they aren't really the big problem. What the administration needs to do is get more judicial warrants, and they need to be more targeted.
I find it interesting to hear that there aren't enough judges to get this done.
We're talking about immigration judges.
Okay. All right. Thank you for, I was trying to put that all together. Like, why would that be a problem? I think seems like we have enough. Wow. In the time we have left, where else you want to go here within the judicial system?
Well, I thought maybe we would talk for just a moment about the Alien Immigration Act. That's another very important case that's floating around now. So the president cannot use the Alien Immigration Act to deport people based on membership in a gang. And the decision came out of the Fifth Circuit. Very, very thoughtful decision by some very thoughtful judges. It's a 2-1 decision. It's eventually going to make its way to the Supreme Court, I'm sure. But for the moment in the Fifth Circuit, that's the law. And the Fifth Circuit covers Texas, Louisiana, that part of the country. So what did they decide? They decided that the Alien Enemy Act really requires something in the nature of an act of war. Gangs are not an act of war. And they stayed their own order. And that's okay. People looked at that and went, wait a minute. Well, the answer is that's not a big deal, because the Supreme Court has separately said you must give everybody under the Alien Enemy Act a hearing. So there's a place to hold a hearing to invoke this defense and deal with it. So we don't need the injunction. As I mentioned to you before, the Supreme Court doesn't want so many injunctions that are not enforceable and create too much chaos. So the judges thought that one through and said, okay, we've got a due process requirement already. We don't have to get involved in this. We won't make an injunction right now. We'll stay our order while makes its way through the courts because there's already this due process requirement. So it's a complicated situation, which is why you have to read all the decisions.
And they vary, don't they, by state?
Yes.
Like the last I heard, California, the governor there, the Trump administration was pleading for them to veto I think you call it despicable immigration law or something like that.
Yeah, some of that varies from state to state. Yes. And I guess the final thing that we maybe should talk about is spend a minute or two on what's called the shadow docket. Now, that has been in the press as well. And this is the Supreme Court's docket where they issue orders without full briefing and decisions. So it's called the shadow docket. It looks like they are trying very hard to create standstills till the cases get to them. And it looks like that's the driving principle behind the shadow docket. Don't read too much into it. They're just trying to hold the status quo, maintain some kind of judicial order, keep the cases moving so they get to them in the regular course of business. And some of this is because I mentioned to you, we're not following the normal process of getting to decree. We're trying to decide these cases in the first 50 days, not, 2 years after we've had the case was filed and we've had discovery and a trial.
Well, isn't that what that's about? The shadow docket is like, let's push this forward, immediate action from the court, don't take time.
No, that's what the shadow docket's not for.
Oh, okay. All right. Thank you.
Shadow docket is really trying to restore regular order. They're trying to get back to, let's let the district court hold a trial. Let's let the district court write a real decision. Let's have the Court of Appeals, brief it. Let's have a orderly process. I believe that's what the shadow docket is seeking. It's not being interpreted that way, and it doesn't always feel that way, but I think that's what the shadow docket is really, people are trying to say. And they really want to get back to not so many injunctions, but the difficulty is that we're in an era where you had some very unusual things happen. No administration has ever tried to deport people under alien enemies for being gang members. No other administration has tried to impose these big tariffs under the IEEPA. There are some very unusual and novel issues being raised. The states and governors and cities and individual businesses are reacting to that, and it's creating a lot of back and forth, and it's creating a lot of chaos. Courts don't like chaos, and they don't like having to do things in other than a very reasoned way. And they're desperately, I think, trying to get to a reasoned place. It's hard in the current environment, but that's where I think they're trying to get to. But at the same time, I think the opponents of the unitary executive and some of the opponents of some of these policies have to do what they're doing in order to try to maintain the status quo. So we have a struggle on how do we maintain the status quo? How are we fair while the case works its way through? The Supreme Court's trying to ride that with very incomplete records because that's the nature of the beast. The government tends to do better in that kind of thing because they're the government, but that's not necessarily a predictor of the ultimate outcome. But ultimately, the American people have to decide what they want.
Isn't the Supreme Court split on the shadow docket situation?
That's hard to tell. You've had some bloody dissents from Justice Jackson Brown. You've had some tough dissents from Judge Sonia Sotomayor. But you've had Elena Kagan a little bit more quiet, and she may be looking at this the way I'm describing it, as we need to get back to regular order. It may be that in a particular case, the way they're approaching it, particular judges don't like it. Sometimes it's Justice Alito and Justice Thomas who don't like it. But the shadow docket, in my opinion, is an effort to maintain the status quo until we get to a reasoned decision. And they used it in one instance, I think, to try to get the district courts to be more orderly in these national injunctions and stop so many national injunctions and think it through and be more careful. That's okay. I think that's a fair criticism, because it was a growing trend on, it's been growing for about 15 years now, this national injunction business, and maybe not in the best interest of the country. So it may have come to a head here, but we just have to be careful, and the Supreme Court's got to do its job. But as I say, the ultimate deciders are the voters at the voting booth.
If you had the whiteboard in front of you and the dry erase marker, and you could just write down the first thing that you feel is a priority within the Supreme Court to clean things up, clean up its act, clean up whatever it might be, priority-wise, what do you think it would be?
That's a really interesting question. I think it would be to rely less on the shadow docket, because it is creating too much distress in the country. It's causing too much loss of respect for the court. And I think that has to be something that the court is always concerned about, maintaining its integrity to the public, because it's no stronger and the justice system is no better than the confidence people have in it. And therefore, were I them, I would try to do much less on the shadow docket.
Gotcha. Yeah. A lot of insight today. We went in many different areas here, all under the umbrella of the justice system. I truly appreciate, Carol, your insight. It's almost as if you're the quick read. You know, I can be online for hours trying to figure this out. Things I thought, confusion. It can get very complicated, especially when you have a docket or you have something that was enacted in the 1800s and how it actually applies now. You're located in New York. You're with Greenspoon, Marder, LLP, correct?
Yes.
If somebody wants to reach out to you, comment, question, whatever it might be, can they email you? Can they find you?
Absolutely, please. Carol.sigmond@gmlaw.com, and it's SIGMOND.
Gotcha. Or instantfeedbacksteve@gmail.com. Would love to hear from you. I appreciate Jesse for checking in with the tariff question before.
Yes, thank you, Jesse. That was a good question.
Good stuff. Yeah. Thank you for today. And we'll keep an eye on all of us and get together soon. Okay.
See you soon, Steve. Thanks.
And get your coffee now before the price goes up again.
Amen, brother. Thank you.
All right. We'll be right back.
Broadcasting from the business capital of the world, this is the Podcast Business News Network.
Hi, this is Terry Crews, actor, former football player, game show host, father of 5, and all-around big dude. I'm also an expert on drama. I know all kinds of drama. There's the good kind that comes with having a house full of kids. There's the bad kind, like season-ending injuries. There's the necessary kind, like having an agent in Hollywood. And there's silly drama, like the drama around my percolating pectorals. And then there's the drama you can skip.
Skip the drama that comes with not having your high school diploma or equivalency. Find free adult education classes near you and finish your high school diploma. Visit finishyourdiploma.org.
Or text diploma to 97779. Message and data rates may apply. Reply STOP to opt out. That's diploma to 97779. And leave the drama to actors like me.
Brought to you by the Dollar General Literacy Foundation and the Ad Council.